In Penal Code Section 597, California has enacted some of the strictest animal abuse laws in the country. Now, the animal abuse laws make it a crime to maliciously kill an animal, to maliciously injure or maim or torture an animal, to neglect an animal by depriving it, for example, of food and shelter and water, or to use an animal for labor that it's not fit to perform. Examples of activities where we've seen animal abuse charged include dog fighting, cockfighting, kids shooting a raccoon with a BB gun, someone leaving a dog tied up in the hot sun all day with no access to water, someone leaving a dog in a vehicle in extremely hot weather, extremely cold weather, in inclement conditions. These are the sorts of things that could potentially get somebody charged with animal abuse. Now, here in California, animal abuse is a very serious crime. It's a wobbler, which means it could be filed as a misdemeanor or a felony. And as a felony, if you're convicted, you could face up to 3 years in state prison. That said, we found that a lot of innocent people get wrongly accused of animal abuse. Sometimes we find that it was really somebody else who abused the animal, but for some reason the finger got wrongly pointed at our client. Sometimes we find that our client acted in self-defense. Maybe our client did injure or kill a dog, for example, but that dog was vicious and was attacking him or attacking his family. And so he was acting in rightful and legitimate self-defense. Sometimes we find that an animal was neglected, but it was somebody else who had responsibility for the dog or the cat or the horse. And really, it wasn't our client's responsibility, but somehow the finger got pointed at our client. Here at Chouse Law Group, we've had a great record of success in defending clients who are in just these sorts of situations and ultimately getting these very serious animal abuse charges reduced or even dismissed.